Okay, so this is a video for the benefit of those of you who weren't able to come to the first week of the term, and for the benefit of those of you who'd like to go over the example. An important example of social scientific explanation. I hope it will be something that we can refer to as we go, as an example of a kind of explanation that might be philosophically problematic. I'm going to give you an example after presenting the schema of explanation that we're thinking about. So we start with a description of something that happens, an event, something happens. There is an event. And we want to explain it. Doesn't matter why, we just have an interest in this thing for some reason, just interested, and we want an explanation. The explanation, according to the schema, has a form such that there are certain conditions, conditions C1, C2, C3, and there are certain laws, laws 1, 2, 3, or generalizations. And under conditions 1, 2, 3, given laws 1, 2, 3, etc., etc., this thing happens. So we have an argument, the conclusion of which is the thing that happens. We can make that a bit simpler and say that we have conditions, laws, and then the phenomenon of interest. The thing I've got at the third step, phenomenon of interest, is a little bit ambiguous, it occurs to me. It didn't when we were talking about this in class, because it's important to see that the thing that is explained is a particular instance of something, an event, an occurrence of something. And the generality occurs at the second step when we're describing the laws. And somehow we've got to get from the laws, which are very general, to the particular event and explain it by bringing it under these laws, sometimes called covering laws. Okay, so I'll give you an example from Hempel's explanation in Science and History. Note that the title is Explanation in Science and History. The issue for Hempel is whether or not this kind of explanation is applicable in history or generally in social science. That's a philosophical issue. But here we go. I'll just put his example on the screen and you can read that in your own time. Do have a think about this example, and I hope it will make sense of the model, which I'll come back to now. So we've got conditions, we've got laws, and then we've got the event that he describes as on a particular occasion, right? On a particular occasion, soap suds emerging, growing, etc. What Hempel calls this is the explanandum event. There is an event, and it is going to be explained. It's the explanandum. And it's explained when we state the conditions and the laws that predict the thing that we have observed. Okay, so the question for us is whether or not this model of explanation applies in social science. And I'm going to give you an example of an explanandum event, which is a legally incorrect verdict. I'm taking this example from a book by, as you can see, Calvin and Zeisel, I suppose, The American Jury, which is a report of a large-scale American sociological study on jurors' decision-making. So what they try to explain in this book is that there are certain conditions under which jurors will return a verdict that the judge regards as legally incorrect. And what they want to do is have some count of the general, the generalities, the laws that explain a legally incorrect verdict under certain conditions. I mean, I should say that the authors do not explicitly apply this model. They don't say that they are, they've read Hempel and they're applying the deductive nomenological explanation of action. As you can see, hang on, that's what he calls it there, 2.1, section 2.1, deductive nomenological explanation. He goes on to give a probabilistic version of the same model, which I'm not going to bother talking about. But it's called the deductive nomenological model of explanation. So it's not as if the authors say, we've read not Hegel and not Nagel, but Hempel. It's not like they say we've read Hempel and we're trying to apply this schema to our work. It's me. I'm saying, can we think of the finding that they produce as a case of this kind of explanation? Okay, so they have this phenomenon, judge-jury disagreement, which in a certain sense is a concocted or confected phenomenon. It isn't that legal professionals, or how can I say this? It's not as if in the procedure of a case of criminal law there is discussion of whether or not a juror's verdict is one that the judge would agree or disagree with. They ask the judges who participate in this study to say what they think. Okay, I'll come back to that. But the two questions that they ask about judge-jury disagreement: first, what is the magnitude and direction of the disagreement between judge and jury? And second, what are the sources and explanations of such disagreement? And when they're talking about the magnitude and direction of disagreement, what they're talking about are the results of a survey that they conducted. And they managed to find 555 judges to participate in this research. And they wrote a survey which they gave to judges to fill in after the case was completed. In fact, they have to fill in at least one question before the case is completed. Okay, and the important point here is that there's a particular method of explanation. Now, I really have to stress this is a very important point to bear in mind, because look, the judge was involved in proceedings as a judge. The person that they're asking was involved as a judge. And they're asking the judge to say how they understood what was going on in the cases that they were answering the questionnaires about. So they're not doing a controlled experiment. They can't repeat a case. A case is a one-off thing that happens. It's an event which occurs just once when a particular person is accused of a crime and goes to have the charge heard in court. That happens just once. There might be types of cases, there might be similarities between particular cases, but every verdict is an individual event, and they're trying to explain it, the explanandum event they're trying to explain. So just as an example of what they mean by reason assessment rather than controlled experiment or whatever else, they give the example of a liquor store vendor who served liquor to a minor. And as they say in this text, the facts of the case were not disputed, but the jury still acquitted the defendant. Why? The law said they should have found the defendant guilty, but they didn't. They came back with a verdict of not guilty. Why? Well, the authors say that the distinctive circumstance, just think back to that model, circumstances or conditions, and then laws, and then the explanation or the thing explained. The distinctive circumstance is that the minor in question was a sailor in uniform. The judge nails down the explanation with the remark, "The jury seemed to feel that if the boy can be taken and forced to fight, he can buy and consume a bottle of beer." Moreover, they say, the judge has little difficulty in empathizing with the jury. As a normal person, as an ordinary member of society, he must be tempted by the same considerations as tempted the jury, which not only tempted the jury, but moved them to come back with a verdict of not guilty. Excuse me. So just have a think about this method of explanation. I don't mean and this is also important, I don't mean the judge's method of explanation. He's just saying what he thinks. I mean the sociologist's method of using a judge to come up with an explanation of the sorts of events that they're interested in. Okay, so they have a questionnaire which they design. Just by the way, it's a bit of an issue for them that they start off with one questionnaire, and they get so far in conducting their research, and then they improve the questionnaire, and they devote, I think, a whole chapter in the book to saying why that's okay, or at least they do devote some discussion to that, because it might raise some eyebrows in methodological terms. Is this okay? But in any case, they have a questionnaire, and you'll see I've got the questionnaire here. It's 2 pages, and you can see at the end there is some space for comments for the judge to say anything that the judge thinks is relevant that the survey hasn't already covered. And you'll see question 3, it says, "Before return of the jury verdict, please indicate how you would have decided the case had you tried it without a jury." And then they have the principal charges and the lesser offences and so on and so forth. And then question 4, what verdict did the jury render? Okay, so here are the results of the survey. It was a survey of 3,576 cases. There were 555 participating judges. And in answer to the first question, we have this result. We have a judge-jury disagreement rate of 24.6% in the direction of jury leniency. Just have a look at that. It might be worth saying that the last figure there, 5.5%, there will be times when the judge or rather the jury come back and they say we haven't been able to decide. That option isn't open to the judge. If you go back to question 3, that question asks the judge to say whether they would have found the defendant guilty or not guilty before they hear what the jury has to say about it. So we include that with a 5.5% disagreement here, where the jury has no decision and the judge either has convicted or acquitted in the judge's imagination, had they tried it without a jury. Okay, so moving on. to this question: what are the sources and explanations of such disagreement? Now, there is an overall explanation, or there is a framework of explanation. I mean, what would you call it? There is a hunch, there is a sense that they have at the end of the analysis of all of the data that they've collected, that there is something very basic going on in cases of judge-jury disagreement. So, wonderful quotation is, I think, they say, the jury in the guise of resolving doubts about issues of fact gives rein to its sense of values. It will not often be doing this consciously. What do we mean by that? As the equities of the case press, the jury may, as one judge put it, hunt for doubts. Its war with the law, another fantastic phrase, its war with the law is both modest and subtle. The upshot is when the jury reaches a different conclusion from the judge on the same evidence, it does so not because it's a sloppy or inaccurate finder of facts, but because it gives recognition to values which fall outside official rules. So the official rules are the legal principles that they should be deciding the case in light of. But there are situations where, to put it slightly differently, the jury have a moral sentiment. They think it would not be fair to convict the defendant. It would not be fair. And when they feel it would not be fair, they hunt for doubts. When they feel that it would be morally wrong to find the person guilty, they use doubts in the presentation of the case. They use what doubts there are to see if they can come to the conclusion that the person, beyond reasonable doubt, no, probably we can't say that, so we'll find the defendant not guilty. Now, the thing is, this is far too general to be a satisfactory explanation of individual cases, because there were all sorts of cases, and I'll just put some examples on the screen. These are examples taken from the book. We've got examples of sale of liquor to minors, larceny, negligent homicide, indecent exposure, another example here of negligent homicide, drunken driving, fraud, attempted murder. So we've got particular cases, and they want to say something, they want to have something that would allow them to predict results, let's put it that way. Where they don't just want to say, generally speaking, so generally and so vaguely speaking, this thing happens. They want to explain particular events. So they get a lot more fine-grained with thinking about explanations that cut across different types of crime and bring it down to some kind of set of principles that the jurors are using, where they feel that it would be unfair to convict the defendant. So, just to give you an opportunity to see how this works, or what's going on in the reasoning of the sociologists, what I would suggest you do now, and even if you were in class, just go over this to see if you remember. Actually, there was a bit of a glitch in the handout in class, so I've corrected that. There are 8 examples here, and there are 4 examples of one legal principle, and there are 4 examples of one moral principle, of a principle that expresses a moral sentiment, not a legal principle, and there are 4 examples of another principle that expresses a moral sentiment. So these are not legal principles, they are principles that express a moral sentiment. See if you can divide these 8 cases into 2 groups of 4. So pause now and see if you can do it. I'm about to go to the next slide. Before I do, pause and see if you can divide these into 2 cases. Okay, just to go to the next step here, I'll tell you what the 2 principles were, according to the sociologists. The first was the principle of contributory fault, and the second was the de minimis principle. Principle of contributory fault is that the victim of the crime contributed to the harm that came to them in some way. So the victim contributed to the harm that came to them. So that in some sense the jury might be saying, well, it was your own fault, and that is not a legally correct principle. So there are 4 examples of that. The de minimis principle is a principle that the law doesn't concern itself with trifles. In other words, if the offence seems to the jury to be really trivial, not worth considering, or at least not sufficient to give somebody a criminal record, so it would be unfair in that respect, they would then acquit rather than convict. So have another go at those 8 examples. See if you can divide them into 4 groups. 2 groups, 4 examples of each of these principles. And I'm about to give you the suggested answers from the book. So pause before I do that if you want to have a go at this exercise. Okay, here are the answers. And perhaps there will be some perhaps you'll have some question about the categorization of these examples here. Perhaps you'll agree, perhaps you'll disagree. We can possibly discuss this again in class, but what I'd like you to think about is whether or not this schema really fits what's going on in this sociological explanation, in this example of social scientific explanation. What are the laws? What are the conditions which, given the laws, explain a particular verdict? So if we go back here, and if we've got that example of the sale of liquor to minors, which serves as an example of the legally incorrect principle that the law doesn't concern itself with trifles, the de minimis principle, we have certain conditions which are satisfied, and then we have the law that I don't mean the legal principle, but the scientific law, the covering law, that jurors use this principle when they feel that the case is, when they feel that there's some unfairness to the defendant in finding him guilty. That's one of the conditions. This law comes into play, that they judge the case according to the de minimis principle and return a legally incorrect verdict. Just to finish, that's the idea. What do you make of it? Does it sound right? Are you persuaded? Do you think findings like this are respectable? Would you call them scientific? If not, could you come up with a better design of study than the one that these sociologists came up with? Do you think there's no such thing as social science? And any attempt to come up with general laws, general statements that are laws that explain things is nonsense. That's the sort of thing we are thinking about this term.